Chief Justice Rabner, Judge Grant, and the honorable members of this conference, I want to start by thanking you all for allowing me to participate and present before this conference on behalf of the County Prosecutors Association, or as I'm going to refer to the organization as CPANJ. We're at a critical moment in our nation's trajectory where issues of social justice and implicit bias are, I would say, finally at the forefront of the conversation, and where we have real opportunity to make meaningful and lasting changes. We know racial and gender bias exists in all areas of our society, and we know the criminal justice system has been acutely impacted. As stakeholders in a system that is so vital to our society, we appreciate the court's attention to this matter. Public trust and confidence in the criminal and civil justice processes is paramount to their success. It's imperative that we utilize every measure in our power to remove bias from our justice system, which at its core seems almost simple: to provide all women and men equal justice under the law. This two-day conference is a unique and welcome opportunity to evaluate how we can improve our state's jury selection process. I hope that this conference will be the beginning of a dialogue and decisive action. We at CPANJ come here with an open mind and a few thoughts that we'd like to share about both preemptory challenges as well as other areas where we think the jury selection process could be improved. We as prosecutors are guided by our professional duty, our moral ethics, and our sense of fairness. Of primary focus in this conference has been the use of preemptory challenges in selecting a jury. We all value the constitutional rights that guarantee the right to a trial by jury and really what is a group of one's own peers. While we believe a review of how our state utilizes preemptory challenges is necessary, we'd also like to argue that it's not the only area in the jury selection process that needs review and reform to ensure that everyone's constitutional right to a fair trial is upheld. Those who favor retention of the preemptory challenge point to four purposes. The preemptory challenge allows the parties to secure a fair and impartial jury. It gives the parties some control over the jury selection process. It allows an attorney to search for biases during the selection process without concern for offending a potential juror. And the preemptory challenge serves as an added layer of protection when a challenge for cause is denied by a judge and the challenging party still believes that the juror may be biased. The Rose Report examined 95 cases in 14 counties and revealed some valuable insights into preemptory challenges. It found, for example, statistical evidence that defense attorneys in criminal cases were disproportionately likely to dismiss white jurors rather than African-American jurors. The Rose Report also found that in criminal cases, prosecutors used approximately 4 challenges and defense used an average of about 6. This is well below the allotment of preemptory challenges allowed to the state and defense. In the most serious criminal cases, the state is allowed 12 preemptory challenges and defense 20. It's important to note that New Jersey has the most preemptory challenges in any state in the nation. The Rose Report also revealed a series of surprising and I would say counterintuitive findings. Attorneys' use of preemptory challenges played only a case-specific and attenuated role in explaining patterns of underrepresentation in juries. Additionally, New Jersey has to determine why jury pools consistently and substantially underrepresent African Americans. But that being said, according to the Rose Report, African Americans were not underrepresented on juries. Fully 10 of the 14 counties studied represented or overrepresented African Americans on juries. For Latinos and Asian Americans, underrepresentation was sizable and concerning in 2 or 3 counties. However, in the majority of all areas studied, these groups were not starkly underrepresented. Further, the Rose Report found criminal juries do a better job of representing Black individuals than civil cases. Criminal juries, which are larger in size, do a better job of representing minority groups than a smaller sized civil jury. In conclusion, the Rose Report found that preemptory challenges are not the problem. However, in the spirit of goodwill and compromise, we at CPANJ believe that abolishing the two-tier system in criminal cases and providing the state and the defense with an equal but reduced number of preemptory challenges is prudent. We recognize that there are demands to moving cases quickly and statistics that are used by the court in order to effectuate that swiftness. We offer, however, that there's an inherent conflict with that objective and the desire to ensure that justice will be achieved through a fair trial by a diverse jury of one's peers. It benefits all, and it is in the interest of justice to have a robust jury selection system, which will inevitably take time. We would therefore not concede to the elimination of preemptory challenges altogether. In addition to the preemptory challenges, CPANJ believes wholeheartedly that the entire jury selection process needs a full head-to-toe review. The Rose Report found that the data used, quote, supports the conclusion that people who appear for jury service do not fully represent their communities, close quote. And that's concerning. While New Jersey courts are doing an admirable job ensuring that minority group members in a jury pool participate on criminal and civil juries, there are areas with the proper modifications could significantly improve the process and allow for broader and more diverse participation by New Jersey residents. We currently select a jury pool for motor vehicle commission records, voting records, and property tax records. We believe that we are definitely missing individuals who do not fit this criteria, particularly in urban areas where a large percentage of the population may be renters, may not vote, and do not drive. We could greatly expand jury service to include those individuals who are on government assistant records and public housing data amongst all other government records, due largely to transient populations, mostly in urban areas. Relying solely on the US Postal Service to deliver jury notifications seems like a system that may be doomed for failure, as individuals are quickly moving, and sadly, our mail system has its own set of challenges. Instead, we should look to modernize the jury notification system with email notifications or opt-in text message alerts. Adequate financial compensation is also necessary to expand the jury participation. While the amount paid to jurors varies widely from state to state, New Jersey currently pays its jurors $5 a day, and it's one of the lowest stipends in the country. By contrast, New York pays $40 a day, Connecticut pays $50 a day, and a federally impaneled jury would be paid $50 a day. By contrast, and this is really only contrast because we don't think this is realistic, on election day, poll workers are now paid $300 a day. We propose adopting some measures which have been adopted in other states, including Minnesota, which provides mileage reimbursement to and from the courthouse and on-site childcare for jurors. In urban areas, rather than mileage reimbursement, public transportation to and from the courthouse would be something that would prove to be beneficial, and parking is critical, particularly in a county such as Hudson County, where parking is so scarce. These are often cited as hardships by individuals when they're called for jury duty, and we would like to heed those concerns. To address concerns of implicit bias, we must increase education on this issue. Law schools, bar associations, as well as the court should be educating jurors on what implicit bias is and how it could potentially impact a jury proceeding. As part of the court's ongoing review of the jury selection process, we suggest direct implicit bias information for prospective jurors, whether it be through an online course or a presentation similar to the one that we saw yesterday. Adding a requirement for CLE credit on implicit bias for all lawyers. I know you're real happy to hear that, but that is our recommendation. And training for judges and court staff on implicit bias, being as they are the ones that are guarding for cause challenges. Finally, there's currently a high degree of variation across the court states on how judges may dismiss a juror. And we believe that more uniformity would be helpful in ensuring fairness in the jury selection process. Establishing guidelines and protocols for judges would be helpful to both the defense and the state. By removing these barriers, we can further our objective of ensuring our juries in New Jersey reflect the diverse community that they represent. Thank you for your time and your attention.